Good afternoon. Welcome to the Court of Appeals. We will consider oral argument today in the case of Dutcher versus Dutcher. It appears that appellant is going to save 3 minutes for rebuttal, which is just fine. And why don't I have counsel state their appearances for the record.
Taylor Webb on behalf of appellant David Dutcher.
May it please the court, Harry Caston appearing for the appellee.
Very good. We appreciate your both being here today. As I implied, but didn't really say, we allow 15 minutes per side for oral argument. Appellant's going to save 3 of that for rebuttal. It probably goes without saying, but I'll say it anyway because sometimes it doesn't seem to go without saying. If you're in the middle of answering one of our questions, when you see zeros on the podium, forge ahead with your answer. Don't foray into new matter, but you don't have to ask permission to continue. If you're dialoguing with one of us, permission granted. And we may even have a follow-up question, and in that event, pay no mind to the zeros on the clock. If you're just rambling on and you see zeros, then it is time to sit down. We live stream the proceedings, so it's important that counsel not stray too far from the microphone so that we can pick up everything that's being said. We often have, or I shouldn't say often, we occasionally have some need to go back and listen to a part of the argument again, and it's helpful for us if we can also be reminded of who is saying what when. So with those preliminaries out of the way then, we'll hear from you, Ms. Webb, whenever you're ready.
May it please the court, Taylor Webb on behalf of appellant David Dutcher. There's 2 primary arguments I am here to address today. One deals with alimony, one deals with the marital estate. I'd like to start with the marital estate issue. The general principle, the general rule is that the district court is required to value the marital estate at the time of the decree. There are certain instances where the district court can deviate from that general rule, but in doing so, the court must articulate its basis for doing so. Here, the court's only basis for not valuing the marital home at the same time as the rest of the estate was that it believed it was bound by the parties' prior stipulation on that point.
Didn't the court also attribute primary responsibility for the 5 or 6 month delay to your client? I thought I read that the trial court had in mind that because it was your client whose trial decisions prolonged the proceedings, that could be taken into account in sticking with the value that was stipulated to when the trial got underway 6 months earlier.
I think that the court did attribute that delay to my client, which I think is frankly not accurate. I also think that ultimately the responsibility for the delay is sort of irrelevant to the question unless there was some sort of inappropriate strategical tactical gaming on David's part. But just to clarify the sort of sequence of events that happened here, on the eve of trial, the custody evaluator, Dr. Christie, changed her report the Saturday before the parties were supposed to begin trial. That change to the report was substantive and dramatically altered trial strategy for David. When the parties began the first set of trial dates, the trial was scheduled for 2 days. David's counsel, waited until he had communicated with his expert, who was previously not a rebuttal expert, to confirm that she would be available in the event he could call her as a rebuttal expert to deal with this sudden and dramatic change in Dr. Christie's report. Upon confirming that she was available, David requested leave to call that expert as a rebuttal expert, which was granted, and the court noted that Dr. Christie's last minute change in her report, was unusual, inappropriate, and sort of necessitated then pivoting to call this new expert.
So you're saying that even if the court did think that it was attributable to your client, the court was wrong in thinking that? Is it?
Primarily, yes, primarily the blame, to the extent that blame is necessary or appropriate here, I guess falls on one, Dr. Christie's last minute change to the report that was a dramatic and sort of unexpected change. And the fact that it took 6 months to resume trial was a result of the court's schedule, which the court apologized for, and a result of Audrey's counsel's unavailability. And again, I don't know that it's appropriate or even necessary to assign blame to any one party, but if anyone is sort of blameless in this equation, it's really David. He didn't know or cause this last minute change to the report. He was within his rights under Rule 26 to seek and call this rebuttal expert, and he didn't seek to delay the trial by 6 months, nor was that to gain some sort of tactical advantage on his behalf.
So had the judge just said, oh, okay, yeah, that'll be fine, and I'm jammed up tomorrow, but I can see you day after tomorrow.
Absolutely.
No problem.
No problem.
It was more happenstance than anything else that it ended up being clear the next May before a date could be found that would be convenient for the court and all counsel.
I think that's exactly right. And I think had the trial proceeded as planned with maybe an extra day here, or it went the next week, then we wouldn't have a problem with using this valuation, because it wouldn't be 6 months stale, right? It's truly this. No one anticipated that we wouldn't be finishing this trial until, or really even conducting the bulk of the trial for 6 months later. And I think the other thing to consider in that equation is it's also just not accurate that the trial would have just resolved in 2 days, but for David's request for this rebuttal expert. The second set of trial dates ended up spanning over 4 days. So regardless of this sort of procedural weirdness and mishap, I don't think that it's actually accurate that the trial was going to finish on the original 2 set trial dates.
But I'm guessing there wouldn't have been an equivalent appreciation of the home within those 4 days if they'd gone as planned, right?
I think that's completely accurate. And
On this issue, generally, sorry, wasn't sure if I heard someone speaking. One of the things they're telling us in the brief, they say it in a few places, but I've got it noted as pages 16 to 17, is that, quote, "The record is devoid of David seeking to set aside the stipulation." Are they right or wrong about that? And I guess more pointedly, did your client ever formally move to set aside the stipulation?
I have a couple of responses to that, Your Honor.
Fire away.
First, I would note that I think this stipulation is more akin to the stipulation in Done Be Done, where the court didn't even need to consider setting it aside because the stipulation itself wasn't binding.
I was going to go there next.
Okay.
I've got a whole set of questions about that too.
I will-
But as to sort of setting the structural / procedural groundwork for it, did he formally move to set aside the stipulation? And if the answer is no, does that matter?
I don't think it matters regardless, but I think the answer is yes. After David's post-trial motion sought to ask the court to set aside the stipulation, and I have the citation for that in the reply, but the post-trial motion asked the court to set aside the stipulation to the extent that was necessary.
Did he do it before the post-trial motion? And does that matter?
No, and the reason for that, I think, is kind of highlights why this stipulation isn't exactly what it's been sort of now construed to be, which is that throughout the second set of trial dates, no one appeared to understand or believe that they were bound by that prior stipulation. No one mentioned the stipulation during the second set of trial dates once. It wasn't, and even Audrey's proposed findings after the second set of trial dates didn't request that the court rely on the stipulation or suggest that the court was bound by it. It asked the court to rely on its equitable powers to use the earlier valuation. It was the court that was the one who first suggested that it was bound by this stipulation. And on that, I think it's really important to note the sort of informality and the context of what that stipulation was at the very outset of trial. This isn't a formal written, to be clear, I don't think there's a certain level of formality that needs to be met, but I think the context here really does matter. This is the first day of trial. This is a informal conversation as we're getting ready to proceed with the trial. Hey, we have 7 witnesses. We have agreed that the appraiser doesn't need to testify. We'll stipulate to his valuation. That's it. That's the extent of the stipulation. And I view that as purely trial management at that point, right? It's, to me, the equivalent of, you have an expert testifying and we're each gonna stipulate that we're not gonna make you go through the rigmarole of establishing their qualifications. We'll stipulate that they're qualified. Let's move to what matters.
I mean, what's curious about, like, what, I think I beat you there. What's curious about this, though, is you led by saying, and I didn't write it down precisely, but in your view, something effective, that the district court thought that it was bound by the stipulation. And I see why you think that from the record, but I feel like there's a little bit of fuzziness. I'm looking at the blue brief, the quote from your brief on page 15, and you say, after reciting the district court thinking that this was a stipulation, the end of that first full paragraph on 15, is the court found, quote, "It would be inequitable to set aside a stipulation." And maybe I'm putting too much emphasis on the word inequitable, but it does feel in some measure like the district court is saying, look, you stipulated, and I just don't think it'd be just to let you out of it, which feels a little bit different than the district court thinking that it had no choice. Do you see what I'm saying?
I see your point. The court's initial statement is, I would use the updated valuation, but for the fact that there was this stipulation, and you didn't again stipulate to a new valuation at the second set of trial dates. But again, I would say that that's exactly the reason for that, and the reason that there wasn't some formal motion to set aside at some earlier point was because no one was operating under the assumption we were bound by it, right? The updated appraisal gets admitted into evidence without objection. There's no comment about the stipulation. The updated valuations of all of the other accounts, including the marital home, gets admitted without objection. There's no comment about it. The court updates the values for every other piece of the marital estate except for the marital home. And even ultimately what matters is that everything needs to be valued at the same time. Had the court used the prior values of all of the other accounts and the marital home, that would be fine. We wouldn't have an issue with that. But it's simply the fact that we have all agreed that there's been substantial change in the 6 months intervening that no one planned for. We've accounted for that with respect to the other accounts. We have not accounted for that with the marital home, and there's no justification for doing that.
But I'm not sure that's exactly accurate in the sense that the trial court seemed at least to be concerned about that at the second trial, at the second trial dates, counsel for the petitioner's counsel did not stipulate to that value, right? At the beginning of the first trial, all the parties stipulated to that value, right? That the evidence came in without objection doesn't necessarily mean that petitioner's counsel stipulated to the increased valuation, right?
Sure, but what counsel didn't do is provide a competing valuation at that second set of trial dates. What counsel didn't do is say, hey, Your Honor, we've already stipulated to this valuation at 1.7 and we're locked in. Nor did they lock that in at the outset. Again, the stipulation was aimed at, we don't need Mr. Weber to testify. And that held true for the second set of trial dates, right? Mr. Weber didn't testify, and because there was no disputing his prior valuation and there was no competing evidence to dispute his updated valuation, nor was there any suggestion that was, inappropriate or foreclosed by the previous stipulation.
So it was an abuse of discretion on the part not to consider that updated evaluation, is what you're saying?
I would say that it's, first and foremost, this is interpreting what the party stipulation actually meant is a legal question. It's a contractual interpretation question, and it's just legal error to have interpreted it to bind the parties at this successive set of trial dates. And to the extent that you need to get to the setting aside, then it is an abuse of discretion where there's no, the only basis for not considering this is simply just this prior informal stipulation. And I don't think that I actually accurately or finished answering your point about the inequities that the court points to. The inequities seem to be about this the courts take that this delay is somehow all attributable to David, which again, I don't think is accurate, but is also sort of irrelevant, unless there was some sort of inappropriate strategic maneuvering on his behalf. And in terms of equity, Audrey herself agreed in her testimony that it would be inequitable to use updated values for all the accounts, but not for the marital home. And there's no conversation or there's no analysis.
I take your broader point. I'm not sure I buy that piece of it. I mean, she's testifying as a fact witness. I'm not sure that her opinion about what is or is not equitable in terms of the legal construct, I'm not sure how much that matters.
Sure.
Am I missing something there?
I don't know that you are, I just think that it's a concession on her part, but beyond that, the district court doesn't engage in any sort of analysis as to whether this would still be an equitable distribution in light of the fact that in light of this stipulation, and it's hard to see how it is, right?
So your reading of the record is that's the reason the district court gives full stop. And to the moment we say that the district court should have looked past the stipulation, there's nothing else for that ruling to sort of hang on. Is that fair?
I'm not quite sure I understand the question, sorry.
Yeah, I meant it as softball, but it was a poorly constructed softball.
Well, that's
What I'm hearing from you both today and in the briefing is that you think that the only thing the district court said about why it was not going to use the updated valuation was the stipulation, that it didn't give some other reason, right?
I think that's accurate, and to the extent there's some other consideration about equity, I think that's misplaced and irrelevant.
Yeah. Can I take the other issue unless?
Yes, please.
Just before you do,
Take the answer
you
then
think
we'll
it's instructive that when the updated appraisal comes in at the second set of trial dates, that there isn't a hue and cry from the other side, hold on just a minute, we have a stipulation as to the value. So it's not just that it comes in without fuss or protest, it's that there is no expression on the part of Audrey's counsel to the effect that, well, this can't come in, we've got a stipulation as to value, that should be enforced by the court. It's that silence means something in your judgment.
I agree, yes. I think that's an important consideration. Again, I think it's, right, this, at the outset, this is a legal question interpreting the effect of and the language of the stipulation, and the parties' behavior at that second set of trial dates, I think illustrates that no one really understood that we were locking in a value to be, at that specific time and forever forward, right? And I think comparing to the stipulation in Knowlton is really instructive there as well.
Okay, can I? Okay. Let me take the other issue, ignore the zeros. She receives $560,000, plus or minus a little bit, from the investment account. Is there anything in the decree that requires her to keep that money in the account?
No.
Okay, so if there's nothing in the decree that requires her to keep the money in the account, and if the argument here turns on what to make of the interest that would be accruing off of that, but she's allowed to pull the money out, then why would it be fair to hold her to that interest when she's got the ability under the decree to pull it out completely?
A couple of responses to that, I think. The court states that it's treating this as savings, not as income. And so if we're treating this as savings, sure, the party has the ability to do as it pleases with that. The court can't compel a party to behave in any particular way with its assets. But if the basis of the court's distribution relies, and the basis of the court's determinations rely on a particular understanding, then that has to be, like, whether the party complies with that understanding is up to the party, but that doesn't factor into the court's ultimate determination. So, right, if a party is awarded a piece of rental property, the court can't compel the party to keep renting that property out, but we're going to, in line with the history of that property, we're going to say it's an income generating asset. If you choose to do something different with it, that's your prerogative, but it's not then the other side's responsibility to make up for that. I think it's the same here. And I think it's really important in considering the brokerage account to acknowledge that, the court repeatedly makes reference to the fact that the brokerage account contributions come primarily from these 3 years of just anomalous income on David's behalf. It's not representative of the the historical practices throughout the course of the marriage. It's not representative of David's income throughout the marriage. And so the court seems to understand that when we're talking about how unique these are, except for when the court is dealing with actually applying the historical practice of the parties with respect to this account. For the first, I would direct the court's attention to Petitioner's Exhibit 38. That's Townsend's summary of the parties' brokerage account contributions throughout the marriage. And I would note that, for the first 17 years of the marriage, the total contributions were $12,000. The brokerage account is a completely different account in 2021 than it was for realistically the entirety of the parties' marriage because of these sort of anomalous contributions that everybody agrees.
So taking all that as a given, let's suppose that the district court did the thing that you're claiming that it was required to do. Let's suppose that it accepts the 5-year average as proposed by Townsend, and then it counts that, it sort of does the math in the way that you suggested, for purposes of figuring out her alimony, or her income for purposes of alimony. And then let's suppose that the economy totally nosedives, the market just totally tanks. Some of us might think it's about to, right? At that point, what then? Is she required to file a petition to modify to reflect that? And then if the economy rebounds, is he required to file a petition to modify? I guess just to put the card on the table, my question is, if we do the thing that you were asking us to do, or if we say that the district court was required to do the thing that you're asking us to say that it was required to do, are we setting the parties up for sort of a never-ending string of modification petitions?
I think you can account for that at the outset and make a modification, you can put parameters on what a modification would require going forward. I think that also presumes a lot more volatility in the market than is ever actually reflected here, right?
But they're telling us that there is a ton of volatility. I don't have the precise numbers in front of me in my notes, but they cited to us chapter and verse the particular months within that same 5-year period that Townsend's looking at. You have rates of low single digits, which is substantially different than the rate that you're giving us. And I think what they're telling us is that precisely because of that volatility, that's the very reason not to do the thing that you're telling us to do.
I would encourage the court to look at the rates. I would note that the rates that they selected were the 3 lowest rates on the entire
It would have been
spreadsheet.
malpractice if they hadn't, but yeah.
Sure. In the same way, it would be malpractice for me to not point out that the remainder of the rates were on par or above what we selected as, what Townsend, I guess, selected as the representative rate. And on that, we do not dispute that there's fluctuations, but I think this is exactly how the court, assigns sort of monthly values to income expenses, right? Anybody whose income varies month to month, the way that we handle that is you take your average annual income and we divide it by 12. Everybody's expenses, no one's spending the exact same amount on each line item in alimony every month. We take the annual, we divide it by 12. Some months it's gonna be higher, some months it's gonna be lower. This is how statute directs us, in fact, to do this, is that whenever possible, the court should be taking the annual, income and using that to extrapolate the monthly income. So this is no different than any other calculation of income, calculation of expenses, and particularly that volatility that we're talking about, again, it does not really bear out in this particular account, and I think particularly now at the level that this account sits as opposed to what it sat at during the marriage, right? If we're talking about $12,000 in the brokerage account, sure, that might be a different conversation. We're talking about, an account where in 2021, the parties withdrew $25,000 more than they contributed, and the account still grew by $416,000. And the other part of this is that, David's income is also comprised in part of stocks, and those stocks are single stocks in his companies, stocks in a single company, which are much more subject to the whims of a volatile market than a Vanguard, effectively a retirement account. This is the type of account that people plan their entire retirement around. And so yes, there are fluctuations, but those fluctuations are designed to be, not so dramatic that you can't plan effectively the rest of your retirement years around it. And so that volatility, I think, is is sort of overblown, or at least is not apparently a problem in considering David's income, but then suddenly it makes this income from the brokerage account, unpredictable. And I know that I'm very out of time, so I don't want to overstay my welcome, but if there are more questions on that.
Apparently not. Thank you. You'll
I
have
would
your,
also just note that that even if the court disagrees about counting it as income, that we have an alternative argument about the line items assigned to Audrey.
thank you. You'll have your 3 minutes on rebuttal. We'll hear from the other side.
Good afternoon, Justices. I'm going to repeat something that I said in the memorandum. Why wouldn't the court enforce a valid stipulation, and not just a valid stipulation, but where we had stipulated to their value?
Let me ask you a question. We'll
Certainly.
just start with the stipulation issue.
Sure.
You repeatedly said in the brief that this was an unconditional stipulation. I ran a control F in the brief. You used that word 15 times, but there's not quotation marks around it. Feels to me like that word is yours, not the court. Why is it unconditional?
Here's why it's unconditional, Your Honor. When counsel for Mr. Dutcher said it on the record, he didn't say this is merely housekeeping. He didn't say, as was involved in, it was either the Dunn or the Knowlton case, we're anticipating another.
Where does he say it's unconditional?
He does, no, that's my word.
Okay.
That's my word, Your Honor. And I apologize for, if I should have used quotations or said it was my word, I apologize. But I stand here before you today, it's my word.
So when a party stipulates to something, are you saying sort of as a matter of law, if not practice or norm, that it is by definition unconditional, that a party can't back out of its own stipulation at some point if circumstances change?
Well, no, circumstances do change, Your Honor. And then you make a motion. And you make that motion, in this case, where it would have been the thing to do, would have been somewhere in those 6 months. And I'll point out to you, Justice Tenney, that Mr. Dutcher did
I think you just
make-
gave me a promotion, but yeah,
Just-
Judge, yeah.
Whatever, anyway, I won't say something stupid, or I'll do my best not to say anything stupid.
Right.
But there was a request for bifurcation
Right.
in those 6 months. So to answer your question, Judge Tenney, sorry for the demotion,
No, I'll accept it, thank you. Keep going.
you make a motion, and the motion could be, well, I don't have to say what the motion would be.
But in effect, isn't that what he does when he testifies? Because if I'm understanding correctly from the briefing and the record, there's a 6-month gap. His testimony comes after the 6-month gap. Do I have that right?
Correct.
Okay, so his testimony comes after the 6-month gap, and in the course of his testimony, he offers an updated appraisal, and there's no objection. Do I have that part right?
Sure.
Why isn't the effect of him saying to the court in a bench trial, here's an updated appraisal, why isn't that effectively saying, hey, I'm no longer accepting this prior valuation? Because here's the different one. What else would the point be of offering a different appraisal if not to say to the court, hey, I'm no longer buying the previous one? What else would the point of that testimony have been?
Well, then make the motion, because there is a stipulation that counsel read into the record where we agreed to their valuation. Make the motion, just like you did a bifurcation, a motion to bifurcate.
Isn't that in effect a motion? When
No.
he gives because we're talking about a factual matter, and he
No.
gives a contrary factual statement with a report. Why isn't that effectively the same thing, even if it doesn't have the label motion attached to it?
Because it's just another piece of evidence. It's a piece of evidence that the trial court could say that a stipulation set aside, but there's a phrase lately, and it's, I don't know whether it's called victim shaming or victim blaming. But in essence, our position was, use your limited time, and even though this trial did go many, many days, our time was limited. Use your time to submit whatever evidence you want. We have a stipulation.
But
It's
then at
not-
that point, aren't you feeding into what Ms. Webb just told us, which is you never said to the district court during that second phase of the trial, hey, we ignore what he offered because he's bound by a stipulation.
No, and I felt I didn't have to, because there is a stipulation. They never made a motion to set it aside. And, Your Honor, we're surgeons in a way. You know, I use the word, justice, and that's the wrong word, and you accurately, and I appreciate you pointing it
So
out.
I didn't mean that to be flippant.
No,
Yeah.
and I'm not taking, Your Honor, I'm not taking it as flippant. All due respect. You make a motion. We are surgeons with our words. We are surgeons with the procedures here. They're very exact. There's a stipulation. And there's no such thing as a formal or an informal stipulation. It was a stipulation read into the record.
One of the things that we've been told by the other side is that the effect of the stipulation is a little bit more limited than your position would indicate. Ms. Webb referred to it as a trial management stipulation earlier. Why is she wrong about that?
Well, then that's what you say when you enter this. This is trial management. But I hope it's not offensive to use the word absurd. It wasn't trial management, it was we agreed to use their stipulation. It wasn't saying, listen, they're going to challenge they're going to challenge it. He just doesn't need to testify, but there's going to be challenging evidence. Well, then maybe it's about not calling a witness, but somehow we would present ours. Your Honor, we stipulated to a value. And that stipulation was never moved aside. And like I say, we are slaves to words. And
Suppose he had filed a motion to withdraw the stipulation. I take it you would agree that a party can do that.
oh, absolutely. Absolutely, Your Honor. Could have said because of the delay, we could do that. And we might have also filed a motion that because of the delay that they set in motion, the account went down by, the investment account went down by more than $250,000. So these would have been strategies or decisions we would have made at that time, that maybe my client should have been awarded a greater share of that investment account because of the delay that they set in motion.
Let's stay on that for a little bit.
Sure.
We had a whole dialogue with Ms. Webb about whether this was blameless, and if not, who should bear the blame for that. Do you disagree with anything she said as part of that discussion?
Well, I'm not so sure I think this whole blame issue, Your Honor, the only reason why so much time on my brief was spent on who was really to blame for it, is that they claimed that they didn't ask for that they didn't. So that's why I set that forth. Things happen. And this is not the first time I've been thrown under the bus by the appellant's counsel for I caused part of the delay. It happens. Delays happen for whatever reasons. But even if the delay was caused by something that on our side or neutral, regardless, and even the fact that they knew they were going to ask for the continuance, and it was a continuance that they asked for, it was set in motion. And I think anybody who's been practicing law for more than a few weeks knows that when you come into court, you may not have that hearing that day, or something may be delayed a month, or 2 months, or 3 months. You know that when there's a continuance, and domestic matters often get set aside for criminal matters or other civil matters that have been pending longer. So they knew that there was a delay, and they asked for a bifurcation on that. And Your Honor, we responded to the motion for bifurcation.
So you're saying if they'd filed the motion to set aside the stipulation, you'd have responded. But what I think they're telling us in response, I mean, this just gets really circular on some level, because I think what they're telling us in response is once David puts forward the alternate valuation in the second phase of the trial, if you had stood up and said, hey, Your Honor, they're bound by the stipulation, then they stand up and say, okay, fine, we move to withdraw the stipulation. And so it becomes something of a circular blame game there. I take your point. I don't think it's without force that if they had made a stipulation, they should have moved to withdraw the stipulation. But their response is, everybody understood that that's what he was doing. And if you intended to still rely on it and ask the district court to rely on it, once you said so, then it would have been a matter of a sentence of printed text. They would have just stood up and said, well, we moved to withdraw it then.
Your Honor.
So I'm not sure what to do with that conundrum.
I don't think it's a chicken and egg argument, it's the conundrum
Yeah.
that you're talking about. Putting something into evidence isn't the same, and you may see it different, Your Honor, and you're wearing the robe and I'm not. You may see it differently, but the way we see it is that we were not required to object to whatever evidence he wanted to put. Go ahead, put it in. We have a stipulation.
But isn't what you are saying, sorry, grammar is hard, isn't what you are saying that this was basically a weight of the evidence question for Judge Koch, in the sense of, the first time the parties stipulated to a valuation of $1.7 million. We come to court after a delay. Now, plaintiff, Mr. Ducher, is saying, nope, valuation $1.9 million, $1.95 million. Why is the court, or are you saying the court is free to decide based on what she sees as the value of both of those pieces of evidence?
No.
Okay.
There's, as she pointed out, there's a stipulation.
You're saying it's just an affirmative waiver, full stop, right?
Well,
Or
you mean as even considering it as a piece of
not?
evidence?
Yeah, I take your
Right.
position to be the moment he stipulates initially, that's it. So it's not a weight of evidence question. It's just,
Yeah, not a weight, like well, do I consider it or not? There's a stipulation. We relied on that stipulation.
Which is much more weighty evidence than,
Yeah,
than another piece of evidence.
Yeah,
It
it's
tables the
not
issue.
that this is another piece of, what weight should I give this other one? There's a decision, and I don't think this is weighing the evidence, so I think the answer is no.
Okay.
That you're not weighing the evidence as to, what weight do I give it? Do I come in somewhere in the middle? There's the stipulation to their value. And that stipulation was entered when they knew that they were going to set the 6-month delay in motion. Not that they knew it was going to be a 6-month delay. And if I could push back a little bit on this idea that, it was really informal and that, it was just a byproduct. There's nothing in I could tell you, I think the proper way for me to say this is, the record is devoid of anything to that extent, or that this was some informal passing in the hall. Is this okay that our guy doesn't have to testify? Of course he didn't have to testify. We were agreeing to their value rather than our value, which was substantially less. I've got a minute 55.
yeah, I think we're going to keep you past that. Can I take you to the other issue?
Sure.
Okay. The other issue obviously has to do with the investment account and what to do with the potential interest. You've made a lot of arguments in your brief, and I echoed some of them today in questions to opposing counsel, about how she has the ability to withdraw the money from the investment account.
Right.
Right. But it does seem like there's a flip side to that. And part of my question is quite frankly echoed in one of the responses we heard from Ms. Webb, which is it's not unheard of in divorce litigation to impute income to someone.
I'm sorry, Your Honor.
It's not unheard of in divorce litigation to impute income to someone based on choices that they have made, right? And so if this money is in the account, and I totally recognize there's a whole fight about what interest rate. Put that aside for purposes of this.
Sure.
If the money is in the account and there is something that we can point to that says there's a set value on the interest rate, and she chooses to withdraw the money, then it does seem like it kind of fits under the imputation of income line of cases, because at that point, if she's not getting the interest, that would be because of her choice. Why isn't it fair to think of it that way?
Because it's an asset, not a savings. It's something that she's free to do with what she wants. And it also goes to the equity issue, Your Honor.
But it's an income-generating asset.
Not necessarily. Sometimes it is, and sometimes it isn't. But
You
it
could say
wasn't
that, you could say
awarded-
the same thing about most income, or a lot of income generating assets. I mean, to use the example Ms. Webb gave us, if you had a rental property, I mean, sometimes the market's up, sometimes it's down, but the point is it can produce that income. So why isn't this essentially the same thing?
There's a big difference between saying averaging income, and which we do all the time for child support and alimony. First of all, there was no guarantee that it would spin off a rate. Let's just suppose that some company in China comes out with a new, something AI, and the market crashes.
Oops, that happened yesterday.
I know. Suppose that happens. What happens that month to Ms. Dutcher and the children?
I don't like to use personal testimonials to help decide cases, but I've got to tell you that I recently received my 401K statement. I've been working for the state for a long time now, and I've consistently paid money into my 401K. I get this lovely report every now and again, and it shows me what that account has generated in the last 3 months, the last 6 months, the last year, the last 3 years, the last 5 years, the last 10 years, the last 15 years. Now, it is, in a sense, speculative as to what that account is going to return for me next month. But it seems to me absurd to suggest that, the Chinese may cause the market to crash, or I may get zero. I mean, there's a fairly credible explanation. No, it's a little bit speculative what exactly the return will be, but financial planners can look at that and say, okay, here's a pretty safe guesstimate about what that return will be. And it seems like that's what this Townsend summary does. Yeah, there's a little bit of speculation that goes into the particular amount, but it's kind of nonsensical, in my humble opinion, to say, given those uncertainties, we can't put a value on that. You know, we're told in the blue brief that 5,000 plus per month would be generated from the brokerage account without invading the principal, without having to make other deposits. That's fairly tangible income, and I think it's the reason why we have many, many cases that say figure out the property first, because it may well be when you get to alimony that you won't need alimony, or you may need less alimony because your property distribution will include some wherewithal to cover your necessary expenses. And it strikes me that this is kind of on that footing. You've got $5,000 more or less, and it may in some quarter or 1 year period be less, and in some other it may be more, but 5,000 plus that can be viewed as income, and we'll take that into account in calculating alimony. That seems like a fairly familiar concept to me.
There's three things, Your Honor. One, there's the qualitative nature of what you're saying. And I appreciate the analogy, but you're talking about your retirement. We're talking about eating the next month, using that money to eat the next month. Mr. Dutcher, and this goes to the equity argument, he doesn't have to rely on that. But my client would have to rely on that. So there's an equity issue, or what's equitable, and that was something that the trial court considered, that she shouldn't have to. And Your Honor, there's a plethora of case law which says, and I've cited it all, that says that someone shouldn't have to use their investment income in order to pay for their monthly expenses. And Your Honor, so that's the one thing. And the other thing, I'm gonna call the second argument, if and if. There's no, and this is actually morphing into the third argument. There's nothing that has been pointed to in the record where Mr. Townsend says that past six, and I want to say it's 16.99%, whatever it is a predictor of the future. And in fact, when I asked him on cross-examination, I'm just affirming what he said. No guarantee. He says no guarantee either way. And to me, Your Honor, I think of no guarantee as speculation. And there's double speculation, Your Honor. If the account gets eroded down because you needed it in order to put groceries or pay the mortgage or pay for gas, and by the way, there's an element of the alimony which was not for the length of the marriage, but is rehabilitative. So 14 years, approximately half of the time of the marriage, element of this is rehabilitative, and you're free to use it the way you want. But the record is devoid. There's two ways you lose out, and that it gets eroded and may never come back. And then what do? Judge Tenney talked about the modification issue. And I know, because I've tried many of them, that in case somebody loses their job, they file a petition to modify. But the court can make that retroactive to that date. What do? 1 month, it's good. You file a petition to modify that, and let's face the reality, Your Honors, you don't get before the trial court for 6 months. What do? 2, 3, 4 months where the account goes down. So even if the account is, even if, and the evidence is not, even if there was some, that Mr. Townsend had said, I can guarantee you that over a 5-year period, 10-year period, 15-year period, whatever the length of the alimony is, this is going to spin off 16.99%. 16.99% of what? The account went down by, I had the percentage somewhere, but $250,000 between the first day and the last day of trial.
But I mean, of course, he's never going to say there's a guarantee. You could, I mean, this comes back to Judge Orm's point. You could look at any kind of appreciating asset, real estate, whatever. If there had been a 50-year trend and it was all upwards, but you asked a careful financial expert, is there a guarantee of future? They're never going to say guarantee because, in theory, the meter could strike tomorrow, right? But I don't know why that necessarily means that a court for alimony purposes couldn't say, well, if it's a consistent trend up, I'm going to follow that trend. I'm not necessarily quibbling with most of what you just said there, but I'm quibbling with that much of it insofar as it relies on Townsend not being willing to put a guarantee on it. I'm not sure how much weight we should really put on that.
I mean, Judge Tenney, I mean, there are an investment is just, what kind of asset doesn't get divided? This isn't a real question. Doesn't get divided in a divorce. You can imagine, I'm just antique furniture, antique cars. You're awarded a car. I can't, the Blue Book value says this thing is going to appreciate to such and such. You're going to be required to sell that. You're required to sell that asset. And there's a very important point that I want to make, and it's this. And the case laws don't say it this way, and my guess is, in your opinion, you're probably not going to say it this way. But the way I interpret the case law, it's what's good for the marriage is good for the divorce. If you did it in other words, what I'm saying probably inartfully, or absolutely inartfully, is that if savings, and applying that to the facts of this case, if the parties saved during the marriage,
Right.
and didn't use that, and this is a key point, and didn't use that savings to supplement their income, and the cases don't say it this way, and you're probably not gonna say it this way, what happened during the marriage is gonna happen in the divorce. Savings is going to be an includable expense regarding alimony. And the other side of that is if they didn't use that to support themselves. And the record is very clear on that. That was one of the findings that I want to say that the trial court repeatedly made, because there were, I want to say 2, but I could be wrong, might have been 3, but it was more than 1, post-trial motions. And the court reiterated that the parties saved, so savings is properly included as a line item in alimony. Good for the marriage, good for the divorce.
And she had line items for savings and retirement in the calculation of her need for alimony.
Your Honor, I believe so, but I didn't review that.
But the other side points out, you can't do both. If and that's why their first issue is in the alternative. If the $560,000 in the brokerage account is inviolate, that is her savings and her retirement, then you've got to take out the line items for monthly saving and contribution towards retirement. Conversely, they have no fuss, as I understand it, with including those as aspects of her demonstrated need going forward. But if you're doing that, then you can't also ignore the fact that she has a return from the brokerage account available each month without having to tap into the principal.
If, Your Honor. And I'm giving a shortcut for what I said was the if and if and if. And if it stayed there. And then again, there's that expression, be careful what you wish for. Because if this court were to start requiring people to maintain an asset and take their freedom away of what they want to do, and this was awarded that way, Your Honor. It was awarded as an asset. There have been some suggestions in the reply memorandum that it wasn't awarded as an asset. I could read to you where the court said it was awarded as an asset.
Indeed, but it's an income-generating asset.
But it was not, and here's where that argument comes in. It was an income-generating asset that they didn't use for their monthly expenses. And what's good for the marriage is good for the divorce. The way they did it during the marriage is the way and again, I could rifle through my notes and tell you which cases said it, but you judges have that before you. That case law that has emanated from this court.
I mean, isn't that kind of the same? I know they're different assets, but Mr. Dutra was awarded, what, $1.3 million from the brokerage account, and she was awarded $500,000. The court anticipated that he would use some of that money to buy a house, but he didn't have to, right?
I don't know that the court, I don't know whether I'm mincing words with you, Judge Forster, but the court said both parties, and I've got the language here or there, where the court says both parties are free to use it.
How they want to.
As each see, the exact language, each party can grow or draw as each sees fit.
Mm-hmm.
And there's another aspect to this where the appellant should be careful what he asks for. Because if the court were to find that the X amount of dollars, that if the court were to, even though Mr. Townsend didn't say, oh yeah, you can predict this out. And Judge Orm, you were saying that, well, I can look at my 401K and I can predict it out, what it's gonna do for
Well,
retirement.
I can't, but investment advisor could make a more reliable
Right.
prediction.
You could look and see your past history, but
It's had ups and downs, but the trajectory has been positive over time.
And I already told you why I feel that there's a difference. But what we're dealing with here is a situation in which, and why, the point I'm getting to, and I will get to, is that the appellant, if the court found this to be income to my client, reaching beyond the fact that what amount would it be? 16.9%? 16.9% of what? Went down by $250,000 in 6 months during trial. Then it would be properly included in child support. Because if it's, I would anticipate the court saying if it's income to my client that she needs to rely on, it's also income that's properly included in child support. And I did do the math on this. Mr. Dutcher was awarded 60%. No, that's not right. He, $1.3 million. So yeah, and my client was awarded 500. So if his child support, if he were to make, so he's got 10, I did the math and why I can't, and why I can't remember it. But he would, if hopefully it suffices to say to the court, he would be making, because he got more than double of what my client made. If the court were to find that, well, that's 16.99%, 17% is viable, well, the same thing goes for his income. Would only be equitable that his would be more than $10,000 a month increase in his income. That increases child support. It also increases his ability to pay alimony. And the court may take a different look at my client's needs if he had an additional $10,000.
Thank you, Mr. Caston. Your time is gone and long gone.
Our fault.
And that was, however, in fairness, largely due to our many questions. Ms. Webb, you'll have your 3 minutes on rebuttal.
I'll start by addressing Mr. Caston's last point. We do not dispute that if the court is counting this as income for Audrey, then the court would count it for David. And yep, that would increase his child support obligation. That would also increase his ability to pay alimony, but his ability to pay is not disputed. We don't dispute that he has the ability to pay alimony. This ultimately only impacts Audrey's side of the equation with respect to alimony, because there's not a shortfall here, right? There's not a shortfall in David's ability to cover each party's ability to cover their own expenses. And so, yes, it would increase, if we count this as income for Audrey, we count it for income as David, it increases his child support payments. That would also decrease Audrey's alimony need, because the child support amount is factored into, her income minus expenses. That's all fine. That's equitable. We have no dispute with that.
Can I ask you about the point also that Mr. Caston made, that and it comes directly from paragraph 117 of the court's findings of fact and conclusions. The court also considers that the parties have traditionally used the investment account as a savings account and pulled from it only for limited purposes. Moreover, the court finds that it would be inequitable to treat any earnings from the account as income. If the court is primarily concerned about the equity here and treating that amount generated by the account as income, why is it an abuse of the court's discretion to make that determination when at the base of all of these determinations is equity?
I think the reason for that, Your Honor, is because that equitable consideration doesn't quite track when you look at the court's logic, right? The court follows that sentence in 117 with the parties are receiving a different percentage of the account going forward, and each party has a different ability to invest going forward, right? So, but that's irrelevant to what our proposal was, right? Each party, yes, has a different amount in their account. We're not asking we're not asking the district court to overlook that. We're saying here's the amount that is in her account right now and how much that generates. The fact that they have different ability to contribute going forward is also irrelevant because that generates what it generates without any additional contributions. And if we're looking at this as, oh, I'm not counting it as income, that falls apart a little bit more when, the difference in ability to contribute going forward is already remedied by the fact that the court has assigned these line items to her, giving her this extra ability to contribute. And so I don't understand, frankly, the court's equity concern on that level, because we're not asking the court to, assume that the parties are making similar amounts or anything like that. We're asking the court to recognize the amount that each party is going to make. And
Which I guess I understand to the extent that if the parties treated this as a savings account during the bulk of their marriage, even though maybe just at the later end of their marriage, but why, and then post-divorce, why should she be tagged with using the savings account that was held and created and benefited during the marriage as her to use on her living expenses where he doesn't have to?
A couple of points on that, Your Honor. This is where I think it's really important to consider what the actual historical practice was during the marriage versus what the brokerage account looks like now. I think this is really more in line with, assume that one party, the parties have saved here and there to the extent they can throughout their marriage in, minimal amounts, but then towards the end of the marriage, one party gets a really substantial inheritance. They take the opportunity to dump that into savings, and it generates this massive account that they have, the returns that they've never seen before, the principal that they've never seen anything like this before, right? And then if you then get divorced, that gets divided equitably between the two parties, which is what happened here. But there's no, that's a one-time event that allowed for this account to be what it is, in the same way that David's income for those 3 years as a result of of the merger at his employment is really akin to him receiving, an inheritance from his employer at that point, right? There's no world in which the parties are going to be able to contribute at that level going forward, nor is there even a need, because this account now, unlike the 20 prior years of their marriage, is self-sustaining, self-growing without any additional contribution, right? So for the first 19, and so I've done a little math here, and I think it's a little bit instructive. It's just, if you look at Petitioner's Exhibit 38 and you take the court seriously that these 3 years are anomalies, I think you can either, do the math on the historical contributions up to that point, or do the math on the entirety of the marriage and excise those 3 years. And when you do the math at what that averages out to for the duration of the marriage, it's either $427 a person or $549, depending on how which formula you're using. And that's exactly in line with what David's proposal was something around $500 to contribute going forward, to be in line with the parties' historical practices. So assuming, the parties did have this as a savings account, albeit very small, did draw from this during the course of the marriage. That's why these calculations on Townsend's exhibit are net deposits, because there's both deposits and withdrawals. And historically, that account was really just funded with, when David's restricted stock units were sold, they put what was left over from paying their expenses into that account. And I would note on that point that Audrey, as part of the decree, gets to continue benefiting from those restricted stock units, so can continue funding that account in the same way that it had been throughout the marriage if she chooses. And again, I don't dispute counsel's point that the court certainly can't compel any party to do anything with its property, but the court has to make certain assumptions in assigning these, in making these determinations and in distributing the property, and whether the parties follow, the court's assumptions is totally in their hands, but there has to be a baseline for making these determinations at the outset, and that's what the court did here, right? And, on that, the reason that Audrey was awarded the marital home was in part because the court presumed and distributed the estate such that Audrey kept the house and David got a chunk of the savings to buy his own home in the same neighborhood so that they didn't disrupt the children's lives. And so with that, I see that I am out of time. If there are any further questions, I'm happy to answer them. If not, I'll submit.
Thank you. We appreciate the arguments from both sides. We'll take the matter under advisement and let you have a written decision resolving the appeal as soon as we're able to get that done. With that, we will be in recess.
Thank you, Your Honors.
All